Welcome to Colorado Criminal Defense with James Colgan.
From the Front Range to the courtroom, this is Colorado Criminal Defense with James Colgan. Welcome back. I'm Lisa Mosbey, your host. When your freedom and reputation are on the line, experience is the only thing that matters. In each episode, we go behind the scenes of the justice system with James, a seasoned defense attorney dedicated to fighting for the accused all across Colorado. Whether you're facing charges or just want to understand your legal options, you're in the right place. Welcome back, James. Let's dive in. Are you ready?
Good morning, Lisa. Yes, I am.
Good. James, we know many officers start conversations by saying they just want to hear your side of the story or let's clear things up. As a former prosecutor and police officer, can you explain why this is often a strategic interrogation tactic rather than just a genuine offer to help?
Well, here's what I've always said about police officers that want to talk to you, and I want you to think about salesmen. How do you get people to talk to you? You don't do it by getting in their face and yelling at them. How do you sell products? You get them to like you. And then if you can get them to like you, they will tell you oftentimes what you want to hear. But the problem with that is that, and it is an interrogation technique. It's basically to try and make friends with them so they will talk to you. It's human nature. It's psychology that if you were talking to somebody that you like, you're more likely to give them information. The problem with that is that in this country, police officers are allowed to lie to suspects. They can lie about DNA results. They can lie about what other people had to say about the incident. They're allowed to lie to potential suspects. Suspects can lie and have that used against them, but it isn't used against the police. So again, it is an interrogation technique that you make them comfortable with you, just like a salesman. They trust you. They start talking to you. And you think, well, they're just wanting my side of the story. No, they want that piece of information to use against you at a later date. So it's deceptive at best.
And then, James, how have recent Colorado court decisions heightened the requirement for invoking your rights? What specific unambiguous words must a person say to ensure that the police actually stop questioning them immediately?
Well, it isn't necessarily new case law, but it's been confirmed time and time again. It has to be unequivocal. You have to say, I want my lawyer and I don't want to talk. If you say, well, do you think I need a lawyer? That is not sufficient for the police to stop talking to you because you're asking their opinion about whether you need a lawyer. However, if you come out and say, I want a lawyer, they must stop talking to you at that point.
And then is that Colorado law or a court decision?
It's actually pretty much throughout the United States. It's through the United
Oh, it
States.
is.
Yeah. Mm-hmm.
Okay. Interesting. So can your silence before you are Mirandized or before you clearly ask for a lawyer actually be used against you as evidence of guilt in the Colorado courtroom?
No, that as a matter of fact, the jury is instructed that your silence cannot be used against you in any way, shape, or form because you're exercising a constitutional right. And the fact that you're exercising a constitutional right can never be used against you in court.
And then if an officer approaches you on a Denver street at your front door, how can you tell if you're legally required to stay and talk or if you're free to simply walk away or close the door?
So that's a couple of different situations. If you're out on the street and the police officer steps up and says, who are you? Why are you here? You're under no obligation to talk to the police. Okay. You can simply walk away and say, no, I'm not giving you my ID. Now, if there's a developed conversation that says, we saw somebody that looks like you, can I talk to you for a second? You can choose to sit there and talk to them with what they would consider a consensual encounter. And if you choose to give them your ID, you can. If they come to your front door, knock on your door and say, are you Lisa Mosbey? You can simply say, I don't wish to talk to you, and shut the door. Now, if they have a warrant, obviously they'd be entitled to come in and talk to you, but simply going to their door, it's like shutting the door on what used to be the old school encyclopedia salesman, right? You didn't have to buy their encyclopedias, and the police have no right to come in your house unless they have a warrant. So you're not required to talk to them at your front door either.
And James, does the concept of an off the record conversation with a detective actually exist in Colorado law, or should citizens assume every word, including those caught on body cams or in the back of a patrol car, every one of those is being recorded for prosecution?
That is most definitely a Hollywood situation. There is no such thing as an off the record conversation. There's no such thing.
Okay. And then police often ask for consent to search a vehicle or a home when they don't have a warrant. We've heard that happen. If you have nothing to hide, why is it still legally dangerous to say, yes, go ahead?
Well, it depends on what they're looking for. And very often where this comes up is as if there are multiple people that live in the house,
Hmm.
roommates. They're looking for something that say, well, yeah, I'm not involved in that. I don't have anything to hide. Well, how do you know your roommate isn't involved? And then you allow the police to come in. And then it becomes a question of whether you actually have the authority to let the police search your roommate's room. But nevertheless, um, you have a constitutional right to demand a warrant. And I always encourage my clients to exercise their constitutional rights. If the police want to search, let them get a warrant. I've seen it happen where people uh, get stopped alongside the road and they say, can we search your car? And they do, and they didn't know something was in their car. Like, for example, a friend left a backpack with drugs in it, and they didn't realize the backpack had drugs in it. They find it in the car, and the friend isn't arrested, but the person driving the car is, because the friend's long gone. But the guy driving the car gets arrested for possession of drugs, and he honestly didn't know they were there. So that's, especially when multiple people are involved, that's why it's dangerous to give consent to search.
And then can those things get thrown out before court or not when you didn't have knowledge?
Well, yeah, I don't know that it gets thrown out before court, but during the litigation process, yeah, you can develop a factual scenario to say, well, this person didn't really know the drugs were back there. The friend oftentimes will show up and say, those drugs weren't his, they were mine.
Right.
Sometimes that happens, but yeah, sometimes that has to be developed through litigation to try and establish that there was no knowledge on the part of the driver that a backpack full of drugs were in the back seat.
But you will be going to court if you want to get rid of that charge. So
Chances
I
are
understand.
chances are really good. Yeah,
Hmm.
chances
Yeah.
are really good. It's not gonna get thrown out prior to going to court.
So, James, a common misconception is that if the police didn't read you your rights immediately upon arrest, the case is automatically dismissed. What is the actual legal reality of a Miranda violation in Colorado?
Well, there's a couple of things there. There's 2 words, custody and interrogation.
Mhm.
So unless you're in custody, which in Colorado basically equates with being under arrest, handcuffs, the whole thing. That's custody. And interrogation means that the questions are meant to elicit an incriminating response. For example, if you're in custody and they're simply asking you your name, where do you live, and what's your date of birth, that is not meant to elicit an incriminating response. But if you're in custody and they say, well, tell me what happened, you have to read them their rights. And a lot of people have the misconception that simply because they're being asked questions means they have to be read their Miranda rights. That's not true. It's only true if those 2 things exist, custody and interrogation. If those 2 things exist, Miranda has to be read.
I think we get distorted views because of like you said earlier, Hollywood. That's a Hollywood perspective. And I think so many of us see the legal system from that perspective.
Well, I get a lot of clients that say, well, they didn't read me my rights. And then when I start to, peel away layers of the onion, I realize that under the law, they didn't have to read them their rights because they weren't in custody or there was not interrogation. So, for example, when you get pulled over for a traffic ticket, okay, and the police officer says, well, do you know what you were doing? Did you have anything to drink? That is generally not considered custodial interrogation. That's considered an investigative stop, an investigative detention, so to speak. Now, if they pull you out of the car, put you in handcuffs, you're now in custody. So any further questioning now becomes custodial interrogation. Does that make sense?
It does. That's crystal clear. Yeah.
Okay.
So, James, does refusing to cooperate at the scene impact your ability to get reasonable bond or be released on your own recognizance later that day?
It can. It can. Some judges would look at that and say, well, this person was not cooperative. So it could affect your ability to get a personal recognizance bond, yes, or an even higher bond. But it's very courtroom specific. Not all judges would hold that against you. Some would.
I think we should define, yeah, I think we should define, is it that you're being silent or you're refusing to cooperate? How would you define refusing to cooperate differently than just refusing to, to answer?
Well, as with everything else, I think it's very incident specific, very fact specific. If, for example, you're saying that you did not cooperate, you didn't do roadside maneuvers on a DUI investigation.
Mhm.
Well, you know what? You're not required to. The law says that's a voluntary statement. You have a Fifth Amendment right not to do them. The court can't hold that against you. If you're in a domestic violence situation and you don't cooperate with the police, let's say you fight the police, you resist arrest, that could be held against you. So it really is very fact specific about what we're talking about. As with anything else in the law, it's very difficult to paint a broad brush and say, okay, this is what applies to every situation. You really have to look at each situation on its own and for its own merit.
But that does help. It creates some clarity that we don't want folks answering questions, but we also want you to cooperate. And so it is very broad and confusing.
Well, I tell my clients the place to fight is not on the side of the street. It's in a courtroom. So, yeah, you may be upset that you think you shouldn't be arrested. The place to do that fighting is in a courtroom, not on the side of the street with 7 police officers who are armed and have tasers. That's not the place to fight.
Cooperate at that point is what you're telling
Co-
me.
cooperate. Cooperate, yes.
James, before we go, is there ever a scenario where talking is beneficial? Can you explain how a pro offer agreement allows a defendant to share information with the prosecution while guaranteeing those specific statements won't be used to convict them?
There are there are statements that can be made under the rules of evidence that will they'll proffer. It's called a proffer.
Proffer.
You
Okay.
will you'll take a witness, sometimes it's your own client, and you'll subject them to an interview with the district attorney or whoever and explain your side of the story. And there's a specific caveat to this statement that the DA agrees that any portion of this statement will not be used against your client unless he testifies at trial and they use it for impeachment purposes. But it allowed, and I've done this on some very complex cases, such as maybe even organized crime cases, where you'll go in and you'll tell your side of the story, but my client may know that it's not going to be used against them. And so they oftentimes will be very open. And it's meant for the purposes of showing the DA that this person deserves leniency without putting them in jeopardy of having it used against them in court. But that's about the only time that I ever allow my clients to talk to the police is when I pretty much know all the facts the DA knows. Because the worst thing you can do is to bring your client in, talk to the DA, and not know what the evidence is. If you don't know what the evidence is, they can trick your client. If you know what the evidence is, you can prepare your client for what the questions are going to be. So it's a much, if it makes sense, it's much safer for me to bring my client in much later in the case where I know what the evidence is, as opposed to the beginning of the case where I don't know what the evidence is.
Let's wrap this up for people who are listening. What do you want them to take away? What's the most important thing that we talked about during this episode today, James?
Well, yeah, I hate to be too flippant, but don't necessarily trust that the police have your best interests at heart. Um, I know that they will very often appear to be very nice, but they're there to charge you with the crime. They are not there to be your friend. And sometimes that's very hard for people to accept. They want to believe that the police officers consider all sides before they do it. I have seen that happen, but I can say with pretty close to 100% accuracy that that's not always the case. It takes the very special police officer that will listen to both sides before making a decision. Most or frankly, they'll tell you they're too busy to listen to both sides. They got to make a decision in a domestic violence case or a DUI. They don't have time to listen to both sides. That's what a court's for. That's what they'll tell you. And so, uh, if nothing else, please realize that the police don't have your best interests at mind, and be very cautious about that.
Thank you so much for your insights today and veering all over and following me with my questions. I appreciate your effort. And this has been very insightful. Thank you.
Thank you very much.
Thanks for tuning into Colorado Criminal Defense with James Colgan. For expert legal advice, guidance, or to schedule a consultation, head over to jpcolganlaw.com. And remember to like, subscribe, and share the episode if you know of somebody who could use it today. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.